to this video. This is a video on describing or the paperwork that was a motion to dismiss, request a contested show cause hearing, or for alternative dispute resolution. And this is for my case. And I do other people's cases too, and this is for my youngest, and this was the motion to dismiss. And so I'm going to read this paper. It's 2-3 pages long, so I apologize, but here we go. Jill A. Hudges was actually my temporary attorney for this case. I had $2,000, and that is it, to pay for my own attorney. And it ended up going really south because my judge was purposely 3 hours late when he knew that I paid for my lawyer. So it got to the point where everything was so expensive that I could not continue to pay my lawyer, so I could no longer use her. Now, I'm going to make a video on that situation more in detail. If you want to hear about that, just let me know. I'll do the video anyways, of course, but okay, let's get started. So the lawyer on the case was Jill Hudges from Matrim Law Group, PLLC, in Missoula, Montana. Montana 4th Judicial District Court, Missoula, Montana, in the reference of my youngest child. It says he was a youth in need of care. And this is what it basically says. Comes now respondent Tamby Mason by through counsel and hereby moves this court to respectfully either dismiss the petition filed by the Department of Public Health and Human Services, Child and Family Services Division, the department, requesting protective services adjudication as a youth in need of care, temporary legal custody. And then it says the Montana Code. Cause hearing to Montana Code, anointed, then there's another code. An alternative dispute resolution with a separate court requiring an unbiased current neuropsychological evaluation for Tamby, and IQ testing and occupational services as recommended by her healthcare provider. Consistent with LIU of temporary legal custody to establish a firm evidentiary basis, proper assistance with goal of reunification instead of removal, occupational therapy. Molly Kimmel outlined clear recommendations and a plan for Tamby that would have avoided damaging the parent-child attachment that comes with removal. The department removed the child without providing any preventive services or implementing the occupational therapist recommendations, which fails to satisfy the reasonable effort requirements. Tamby disputes issues of material fact presented in affidavit in support of petition for emergency protective services adjudication of the child as a youth in need of care. Temporary legal custody served on July 12, 2019. Tamby also objects to the failure of the department to fulfill the requirements of due process. This request meets 10-day response period. The department failed to meet its procedural requirements. The department failed to fulfill the procedural obligations under the code. The court code is 4134231. Because no reasonable services have been provided to Tamby to prevent the removal of the child from the home. Tamby's occupational therapist outlined a clear path for parental success. Molly Kimmel described Tamby as having good potential to achieve established goals to address documented impairments by participating in occupational therapy. Instead of following these medical recommendations, the department removed the child in its first week of life, despite the child being healthy, and the known damage to children that removal from parents brings. Removal of an infant implicates different services than removal of an older child. Let's see. The parent-child relationship plays a crucial role in early childhood development. The department removed the child from Tambi's care due to her former termination proceedings. Tambi has not received due process because no immediate danger existed. No services were provided to avoid removal as required by Code 413-4231. She was not served with the 60-day report at any time. Tambi was also served with the department's affidavit within 2 working days, or was not served with the department's affidavit within 2 working days of removal, as required. The department has not met its burden of proof to satisfy 413442, nor has it complied with the requirements of due process. The department has violated the child's constitutional rights to be with his mother and violated Tambi's rights to be free from unreasonable search and seizure. Parents have well elaborated constitutional rights to live with their children. That is an essential liberty, interest, and protected by the 4th Amendment. 14th Amendment guarantees that parents and children will not be separated by the state without due process of law, except in an emergency. Let's see. Ordinarily, under the 4th Amendment, government officials are ordinarily required to obtain a prior judicial authorization before removing a child from the custody of a parent. However, officials may seize a child without a warrant if the information they possess at the time of this seizure is such provided reasonable cause to believe that the child is in an immediate danger of serious bodily injury and that the scope of the intrusion is reasonably necessary to avert the specific injury. We clarify that seizing a child without a warrant is excusable only when officials have reasonable cause to believe that the child is likely to experience serious bodily harm in the time that would be required to obtain the warrant. We began the Rogers from the settled premise that social workers violate the 4th Amendment by removing children absent a warrant or exigent circumstances. Malnourishment and disorderly home conditions do not present an immediate risk of serious bodily harm. Rogers thus makes it clear that when social workers investigating suspected abuse or neglect can reasonably obtain a warrant without significantly risking seriously bodily harm to the child in question, the 4th Amendment mandates that they do so. This conclusion finds support. Long-standing 4th Amendment proceeds. Officials may remove a child from custody of its parent without prior judicial authorization, only if the information they possess at the time of seizure is such as provides reasonable cause to believe that the child is in immediate danger of serious bodily injury and that the scope of intrusion is reasonably necessary to avert the specific injury. In recent Ninth Circuit case, the court found evidence that separating children from their mothers or fathers leads to serious negative consequences to the children's health and development. The damage of the removal must be weighed against the need to protect the child from harm. A court must weigh whether the imminent risk to the child can be mitigated by reasonable efforts to avoid removal. It must balance that risk against the harm and removal may bring. The department has not met the burden of extenuating circumstances of abuse or neglect required under well-settled law to qualify for removal without a court order. The medical records show that children The child was in good state of health at the time of removal. Staff described Tambi as attentive and appropriate with her infant. Occupational evaluations indicated that Tambi is moderately functioning and has a good potential to achieve established goals to address documented impairments by practicing in skilled occupational therapy services. Occupational therapy, Molly Kimmel recommended semi-independent living or independent living with a frequent checks for safety of Tambi and the child. Additionally, Molly Kimmel recommended Tambi to receive life coaching services and commented that Tambi has good long-term goals which could be achieved with adequate support. Tambi requested these evaluations and recommendations be followed through with alternative dispute solution instead of damaging the attachment between the mother and the child through an unwarranted removal, temporary legal custody by the department. Respondent disputes facts represented by the department and disputes the need for removal. Tambi asserts that the department can't establish through evidence that she has caused physical abuse or neglect to the child. And then the code 413-102-20 defines physical neglect as either failure to provide basic necessities including but not limited to appropriate adequate nutrition, protective shelter from the elements, appropriate clothing related to weather conditions, or failure to provide cleanliness and general supervision, or both exposing or allowing the child to be exposed to unreasonable physical or psychological risks to the child. The department has not established that any of these have occurred. The administrative rules in Montana define sustainable reports in 37.47.602 as after an investigation, the investigating worker has to determine by the preponderance of the evidence that the reported act of child abuse or neglect or exploitation occurred, that the perpetrator of the abuse and neglect or exploitation may pose a danger to the child. The department has not met its burden of proof to establish that Tambi has committed such acts and that the report of sustained Tambi disputes the diagnoses described to her from her past case. Tambi was involuntarily medicated as a foster child and has since discovered new clearness of mind and capabilities with her achievements of majority age and independence. Recent health care providers have indicated her current diagnoses are limited to PTSD and anxiety, pending further evaluations. Tambi wishes to secure third-party impartial neuropsychological evaluations by Dr. Silverman and Dr. can't pronounce that name, IQ testing and occupational services as recommended by Dr. Ira Gaddy and Molly Kimmel. Tambi highly disputes facts attested to petitioner affidavit in addition to arguing that many facts that support her custody have been left out of the department's petition. The child's medical evaluation files indicates that the child was healthy and strong in the week of Tambi's care. Now, therefore, respondent respectfully requests that this court dismiss the petition of the department or in an alternative, grant a request for a contest show cause hearing or order Tambi to receive a third-party neurological evaluation by Dr. Silverman, IQ testing, occupational therapy services prior to any legal custody order and treatment plan. Order any other relief that the court deems just for being proper. So, I also apologize about the bad quality of the camera. Okay, so I want to talk about this. So, that motion firmly and clearly explains that I was innocent and that they didn't give me a chance to parent properly. I did, in fact, have a safe place to live. It was a shelter for families and children. So I was also living in a house full of families and other children. And it was safe. It was under lock and key, technically keypad. Everything was appropriate. I should have been released with my child to the shelter, but instead they removed my son immediately and did not give me a chance to prove what I was able to do parent-wise and give him safety and love. They did not have really any proof and evidence. Even with my first case, it was more of, well, we know you're disabled, so we're taking your kid. It wasn't, oh, well, there's a danger issue and we need to, take the child because we're scared that there's going to be any danger to the child. And the judge knew this with my first case. I did get a second judge with the first case, and that judge has known me since I was 9 years old. Conflict of interest. He didn't even care about the case. He just signed my son away, and I was threatened to sign my rights, or I would never be able to see my son again, and I would never be able to have future children. So the minute I had Zach, they came into my life like a bulldozer, and there was no really proof and evidence of anything, and they just took my child. I have other recordings that I can post on here as well. Those will be different videos. But yeah, I tried to get my case transferred. In the beginning of my case, I was lied to by my workers. They told me that there was no such way to transfer a case, and that they would not move my child. I was very concerned about my son's well-being in the house he was in the foster home. He came to a visit with a bright red mark on his forehead, which I think I took a photo of. There was a gash on his knee where there was a pool of blood all over his pants. There was no way that at that age my son was like crawling or rolling over, like he could barely roll over. And the fact that he had those injuries didn't make sense because he couldn't have done it to himself, playing or rolling around or anything like that, or crawling. So it didn't make sense why that was happening. And the only plausible explanation, because of his age, was someone did that to him. So I was trying everything in my power to get him moved into a new home or into a new space, but CPS would not listen. I even called the child abuse hotline. What they did was they they had the same department that I was concerned about, the same department that I was reporting. They had the same department investigate themselves. What do you think ended up happening? Obviously, they didn't find anything on themselves because, well, who's going to implicate that something's wrong with them? They're not going to do that because they're going to get in trouble. So obviously that was very broken and didn't make sense in any least. I will do more videos on this, on the CPS topic, DHS. Several people call it different names, and I'm sorry I didn't get all of them. But with this topic, I will be doing multiple of these on my case for documentation. Now, if you want me to do a video, a full detailed video on your case, on your situation, on whatever's happening in your case, I am willing to do that. Just email me. I will put my email in the description box below, so you can be able to contact me, ask me questions, and give me your story and as much detailed words as possible and your court documents so I can be able to show what is said and stuff like that. So I hope this video was helpful, because I know that there was some legal stuff in there that would very much help somebody else in this situation. Legal laws, things that CPS did not follow, that they should have and didn't. And I'm pretty sure that most cases consist of those rights being violated. So I hope that they help, and I will see you for the next video. Bye.